Are you able to see what participants are there?
Yeah, we're in right now. There's
Okay,
2 attendees so far. Hey guys, let's give a few more minutes and then we'll get started.
great. All right, Chris, you ready to get started?
Sure am.
All right, very good. Let's get started. Folks, my name is Andy Cook, and I'm a financial advisor with Edward Jones in Briar Creek Shopping Center here in Raleigh on the eastern edge of Durham. My branch partner and office administrator is Hilda Morello, and we're both here to help you and others make important financial decisions. And because many of you haven't met me, just a quick bio. I was born and raised in Southwest Virginia, started my career right out of school here in North Carolina, began my career in North Carolina as a banker right out of school. And then since coming here, my wife and I have raised two daughters who are now on their own, and we are seriously enjoying the empty nest. And as a commercial banker, I developed a passion to help people with planning and better investment performance while working primarily with business owners who poured so much of themselves into their businesses. And often they didn't have the capacity to put the same amount of effort into their family's financial future. And so they needed trusted advisors to help them make the best decisions for their family and for their business. Joining me and speaking a little bit later is Chris Whelms. Chris is the estate planning attorney and founding partner of Hopler, Whelms and Hanna. And Chris and Adam Hopler are now in their 10th year as a firm. Chris and Edward Jones have worked together on a number of clients to help them create plans to protect their families and their assets. And estate planning is Chris's and his firm's primary focus, which is important when you want to be sure your loved ones are protected. Now, I'm going to talk briefly about the Secure Act and then turn it over to Chris to discuss financial and legal perspectives of estate planning. We will allow time for questions at the end, but feel free to unmute yourself or raise your digital Zoom hand if you have a question during our presentation. Now, the Secure Act is one of the most impactful but least understood pieces of legislation. It was passed by the House of Representatives on December 17th, 2019. 2 days later, it was passed by the Senate, and then the very next day on December 20th, 2019, it was signed into law. And so given the time of the year, the timing of the passage of the bill, the minimal press coverage it received, and then coronavirus hitting our shores just a couple of months later, all of that conspired to keep the Secure Act in the dark. And so I'm going to just shed some light on it. So first, let's talk about required minimum distributions, or RMDs. So the Act increased the RMD age from 70 and a half to 72. So if you were born on or after July 1, 1949, your RMD age is now 72. So you've got an extra 18 months of tax deferred growth you can have in your IRA or 401k. If you were born on or before June 30, 1949, So therefore you were 70 and a half before the Secure Act actually went into effect, then your RMD age remains 70 and a half. Now, age limit on IRA contributions. If you have earned income in retirement, there is no longer an age limit for making traditional IRA contributions. Now, here's the interesting thing, because RMDs are still required at your age 70 and a half or 72, like I mentioned earlier. It is possible now that you could both be contributing to an IRA and take in required distributions in the same year. Just an interesting quirk of the Act. Qualified charitable distributions, or QCDs. Now, a lot of folks receiving, who were taking RMDs, were using qualified charitable distributions to reduce their taxable income. And the QCD, which has been around for several years, just allows an RMD recipient to send their RMD, or a portion of it, doesn't have to be the whole thing, directly to a charity or group of charities, which then that RMD, or that portion that's sent to the charity, is not considered taxable income. Now, the age that at which you can make a qualified charitable distribution has not changed. It's still 70 and a half. However, if you make any deductible IRA contribution after your age 70 and a half, which, as I just mentioned, is now possible if you've got earned income, then the total amount, the cumulative amount you can contribute as a qualified charitable distribution is reduced by the amount of that IRA contribution. So, for example, if you contributed, the maximum you can do in QCDs is $100,000. So if you made a $7,000 contribution to a traditional IRA, then your limit would be reduced by that 7,000 down to 93,000. In any case, a lot of moving parts. That's definitely, if you want to pursue that strategy, for sure, I recommend you talk to your tax professional about that. Stretch IRAs. So prior to the Act, and some of you may have benefited from this, all individual beneficiaries had the option to stretch RMDs, because when you receive an inherited IRA, you have to start taking RMDs immediately.
And did you have a slide that you wanted to show?
Oh, sorry. My apologies. Thank you. Let me share. Thank you so much, Chris. See, that's why I like having Chris as part of the team, folks. He's paying attention. So going back to stretch IRAs. So prior to the Act, all individual beneficiaries had the option to stretch required minimum distributions across their lifetime, which allowed for smaller distributions and therefore more tax deferred growth. Under the Secure Act, distributions for many individual beneficiaries is now required to be distributed over a much shorter 10-year period when the account owner's date of death is January 1, 2020 or later. Okay, anyone who passes prior to January 1, 2020, it doesn't apply to those situations. Now, this particular change in the law, reducing that stretch to a 10-year period, it does not apply to eligible designated beneficiaries. Now, what are those? Those are, and the most common is a surviving spouse. It does not apply to that situation. A minor child of an account owner. Now, once that minor child reaches the age of majority, then the 10-year rule goes into effect. A disabled or chronically ill individual, or an individual who is less than 10 years younger than the IRA owner, or is older than the IRA owner. Now, the Secure Act did not change the rules for non-designated beneficiaries like charities and non-qualified trusts, but the payout rules in those situations depend on whether the account owner died before or after their required beginning date. And the required beginning date is simply the date at which they have to take their first required minimum distribution. If the account owner dies before the required beginning date, then the organization has only a 5-year period to distribute the entire account. If the account owner died after the required beginning date, then they have the life expectancy of the account owner to take all of those distributions. Now, the Act's rules are particularly tricky when it comes to trusts and could affect plans that are already in place. And so if you already have a trust set up and it's the beneficiary of your retirement account, I can't emphasize enough how important it is that you revisit it with your estate planning professional, such as a person, for example, as Chris Wilms, to help ensure that the Act doesn't affect what you want to accomplish with that trust. So what does all this information on beneficiaries mean for you? Well, it really depends on the type of beneficiaries that you have, the type of account that could be inherited, the size of the account, and your concerns with tax burdens on your heirs. And my job is to help you think through the implications and potential solutions for all of those issues. Now, Chris, I imagine that the passage of the Secure Act and going into effect just over a year ago required you to make some changes in how you would typically advise people, even in basic estate planning situations. So
yeah, well, I mean, when it passed, well, before it passed, we kind of had there were different versions being sent around between the House and the Senate. And so we were kind of watching it closely. And we weren't really sure what was going to happen or if it was going to happen before the end of the year, but it did. And I mean, if I had to summarize the Secure Act in a nutshell, on the surface, there's some really nice benefits, right? You get to wait longer to take distributions if you want. There's some features available, with the Secure Act, but then sort of just beneath the surface, now we have this other problem, and that is distributions being made, thinking one set of laws was in effect, and now a different set of laws are in effect. And so a lot of times what we would do on the front end is we would create these trusts. And like I think you alluded to this earlier, when you create a trust and it's the beneficiary of retirement when you die, instead of a child, typically what would happen is that you would have special language in the trust to feed that distribution directly to the child. But because the child would be so young, their minimum distribution amount would be peanuts. It would be negligible enough that we could just route it through the trust and give it to the child. And by doing it that way, we minimize the tax burden. We're able to use the trust as a tool to preserve the estate or to preserve the assets for the benefit of the child. But the minimum distributions that would still have to go out could just go to the child and be put in a special custodial account or something.
right.
Well, with the Secure Act changing, now you got to reconsider, because what happens now is you get that benefit until the child's 18. But usually when we do estate planning for folks, we're not stopping at 18.
Right.
An 18-year-old with dead parents is a dangerous combination, especially when you give them a bunch of inheritance. And so a lot of times people will want to go beyond that to 25 or 30. And so with the way that the RMDs are set up, a child would be able to take that minuscule amount out, but when they hit 18, now they've got 10 years to get it out.
Yeah.
And so now we're going from 18 to 28, and this kid's going to receive the entire bulk of their inheritance. Well, not everybody is comfortable with that. Not everybody thinks a 28-year-old
Right.
or someone shy of 28 who's getting distributions according to the most tax advantageous way to handle it, they're not going to maybe be responsible enough for that. And so then what happened overnight is a lot of people's estate planning got undermined by this law, especially if the bulk of their estate included retirement accounts. And so what we ended up doing is, as soon as it passed, we had Christmas break, we came back and we sent out like 500 letters saying, hey, your estate plan might be messed up. We need to talk about getting it updated to comply with the new version of the laws that are out. And we were going back in there and creating new mechanisms to deal with this problem, to make sure that we can take advantage of the tax part if we want to, but we're also making sure that we can hold it back for the benefit of the kids if there's a better reason to. So it definitely took some rethinking. We kind of had to reinvent the wheel And there were a lot of attorneys like me scrambling to try to find the best solution from the best resources to kind of figure out what were the high minds that are smarter than all of us thinking about how to handle this. And so then we were pulling a lot of stuff from different sources, but came up with a solution pretty quickly. And I'll just add, these kind of changes don't come up that often. I mean, we had a pretty substantial state law change in 2018, and then the Secure Act in 2020. I mean, prior to that, amendments to the law in this area are pretty nominal. Maybe we'll have a dollar limit on something and we'll increase that dollar limit or something like that, but we don't really have substantive changes to the law that frequently. So it was a bit unusual for us, but it's definitely taught me something about preparing for that possibility that everything we've done will be upended and we need to make sure that it gets fixed.
And I think for CPAs as well, one of the challenges was when it came. I mean, it's not like you had all this time to prepare. I mean, it passed on the 20th, and 11 days later, it's in effect.
Yeah, it's amazing. Usually you have a lot more heads up. There's an effective date that's set out a bit with most statutes. So this one went into effect right away. And there was very little time to plan. Certainly we're not, able to accommodate 300 new estate plans before the end of the year, to try to fix all these trusts. But it's still, I mean, I would still say trust planning, even though we had that sort of radical change, trust planning is still a very good practice for a lot of people. If you have, young children or children with, where you want to make sure that you're managed. We call it dead hand control, which is a terrible name for it. But basically, we want the ability after you've died to extend your hand into the pot and making sure and setting conditions and doing all the things that you want to do to make sure your kids don't turn into trust fund kids and that they're responsible adults and so, but making sure that they also don't starve. And when there's a big pot of money sitting here that could feed them. So, if those are generally your desires, the best way to handle that is usually through some sort of trust planning. But I may be in the minority of attorneys that say trusts aren't for everyone. I would almost say you need a couple of good reasons to need a trust. Like there are always advantages to having a trust over something simpler. But in general, I look for that plus maybe another actual necessity before we start talking about trust planning, because when you start involving trust, now you've got a much more complicated estate. And right. When I say complicated, I don't mean complicated to deal with after you die. I mean complicated on the front end to set up and maintain, more complicated than otherwise. But on the back end, the idea is that you're making it more streamlined for the folks after you. And so the way I see it is before you make your life a little more complicated, let's make sure it's necessary. Let's make sure there's a very important goal to you that we're accomplishing by going from a simple will to a trust. I mean, I find in my practice, we do a lot of litigation in our practice, but we have like a whole department that deals with, when granny gets snatched and taken to another state and she's forced to make a will. We deal with, elder exploitation. There's a lot of scams out there where elderly people are getting exploited. So we handle a lot of that stuff. And, I see all kinds of issues that pop up in that world. And the most common is involves spouses and children, or successive spouses and children from a prior marriage. I think if you're in that particular situation, you almost always want to go with a trust plan of some sort, because I can tell you war stories galore over situations where our laws are just not suited for that kind of relationship. And they just don't anticipate that in the way that the laws are designed, and some really unfair outcomes happen, and you end up with a lot of people refusing to speak to each other.
And you're talking particularly when those children have not reached the age of majority, correct?
Well, yeah, but in addition to that, you may be dealing with adult children too. So, yeah. Well, my point was basically this: as a general rule, from years of litigating these kinds of things, I have found that simpler is better. If you have a plan that can be expressed simply, or after some thinking, we can substantially accomplish your objectives with something simple, that is generally better to head off potential pitfalls on the back end. So before we go and say we're going to take that general principle and set it aside because your other goals are more important, and of course we'll try to mitigate every way we can the potential for headaches on the back end. But before we make it more complicated, let's make sure that it's the good outweighs the bad with that. So I will tell you, there are some lawyers who think everybody with a pulse needs a trust. I'll say it depends on the state. I mean, like in North Carolina, I would say that's my general principle of how I approach this issue. But each state has its own laws about how that stuff's administered. And so there's not like a uniform code where you go from state to state and you have the same rules and the same process. That just doesn't exist as far as I know. Each state is vastly different in how it creates it. So if you come from California, right, I would say everyone in California who has a pulse probably would benefit from some trust planning, because from my personal experience and from experience of others, that the probate process there is horrendous. It's not something I would want to put anybody through, and we can use trust to get you out of that process. So it also depends, I guess, on geography or where you may end up as well. So that may be a factor to consider.
So folks, you just heard Chris, an estate planning attorney who often is paid by the hour, just state a principle that by its nature is designed to reduce his billed hours. So mark this date on your calendar. The next time you hear someone making a nasty joke about attorneys, tell them about Chris.
Yeah, we're working real hard to flip the perception on that. So let me do this. Let me see if I can go back to sharing my screen. Let's see. Okay. All right. So you see that, Andy?
Yes, I do.
All right. So wonderful. So there's I guess when you walk into an attorney's office, or you're just thinking about what do I need, right? There are some things, if you walked in off the street and you said, Chris, I've never met you, I'm not telling you anything about myself, what documents do I need to plan my estate? I would say, well, there are some things that everyone probably needs. One is at a minimum a will, which expresses your wishes about who gets what when you die, who's in charge of carrying out those directives, and who are you recommending gets appointed to raise your kids if you don't have kids, or if you have kids that are in need of raising. The others are a durable general power of attorney. Now that's only effective while you're alive, and it's generally designed to help avoid court involvement in your life. That's what a lot of this planning is, right? The court system has a system set up to deal with all the issues that pop up in your life, like you get dementia and you can't manage your own affairs anymore. Well, we have a court process to deal with that. The problem is, and I hope our legislators forgive me, but that system is trash, and I would not put anyone through that process unless it absolutely was necessary and there was no alternative. So often that's the case. I mean, only about 30% of people plan, and so about 70% of people have to deal with the consequences of that. And I just, for extreme examples, we've had cases where one spouse was the breadwinner, and that's the one that got dementia, and so the other spouse is the legal guardian of that person. And now all the income that comes into the house, that they have to report to the court, and they have to show receipts and show how much money they spent on toilet paper and all the groceries and all the haircuts and all of that stuff, right? And now all of a sudden, this woman's personal life and her husband's personal life is all in a public record somewhere, and she's having the court audit her to make sure she's spending her husband's money appropriately and not too much in one column or the other. That's a process that can be avoided fairly simply. I'd say if you walked in my office and said, well, I can only get one document, as preposterous as that is, it would probably be the durable general power of attorney, because I see the insane headaches that saves on the back end. Kind of going hand in hand with that is a healthcare power of attorney, and that's sort of the same thing, except it's related to medical care instead of your financial life. And then an advanced directive. Now, if someone calls me and they say, I need a living will, I don't actually know what they want, because there are so many terms. Lawyers are terrible at naming things, right? 9 out of 10 law firms, I think, are named after the lawyers, because we were terrible at naming stuff. The same goes with documents, okay? So a living will is a document that tells the doctor in the future what you want as far as your life prolonging measures are concerned. So do you want to withdraw life prolonging measures? Do you want to leave it up to your medical power of attorney? Do you not want certain measures in certain circumstances and want other measures in other circumstances? All that is spelled out in a living will, which is called an advanced directive. It has absolutely nothing to do with your last will and testament. It has absolutely nothing to do with living trust. So you can see how easy it is to get confused. Now, trusts, again, are always part of the equation, and usually I don't start off talking about trust with a client when someone comes in. I'm asking about family, I'm asking about assets, I'm asking about goals, and if I hear flags that make me think a trust would benefit them in any measurable way, we're talking about that. But usually, I mean, if someone comes in, if a lady comes in, she goes, I've got $200,000 in a checking account and a car, and I want to give it to my 45-year-old son. That person may not need a trust, right? There's no flags at this point. I might say, well, is he an adult that's responsible and you have no concerns about him receiving that inheritance and doing anything irresponsible with it? And usually they'll make a joke about that, and then they'll say, no, I don't actually have any concerns, and then we move on. And so that conversation of a trust may never come up in a conversation of this type. But I will say, in today's age, when you see it on TV, you see wills, and you think, and they talk about the reading of the will, which is not really a thing. I mean, I've been asked to be involved in something like that, but it's not an actual formal thing. It's not something that has to be done or is legally required. There's no real legal justification for that. So a lot of what gets talked about wills in the media and online and in media or on TV is, this will being this sort of dispositive document that controls anything and everything. And it's just not so. I mean, it may have been at one time, but now there are so many other mechanisms that control where property goes when you die that for a lot of people, the will is just the leftovers, the loose ends. So, if you rent and the majority of your estate is tied up in your retirement account, your life insurance at work, and you maybe have a small banking account, well, your will's probably not going to control much. I mean, you probably have beneficiaries for those things. And if you have a beneficiary named directly on an account, it really doesn't matter what your will has to say about it, because it's going to go directly to that person regardless. So, in today's age, a will is really for everything that doesn't have a superior mechanism. So, for example, if you buy in North Carolina, generally speaking, if you buy a home with your spouse, North Carolina has a special form of home ownership called tenancy by the entireties, and which is the default position if you and your wife's name or you and your spouse's name is on a deed. And what that means, it's got special protections, but it also means that you can't separately dispose of your half of the house in a will. It means when one of you dies, the other one automatically inherits it as of the date of death without any filings that have to be done. Just the mere fact of death by operation of law causes that home to be owned by the other spouse. But now it's owned individually. And so now it would be controlled by the surviving spouse's will. But in general, wills don't do much until you die. Okay, so they're not there to really have any impact while you're living on things. I'd say the one exception is if you became incapacitated and your minor children needed a new guardian, but you were technically still living, they would probably look to your will to see what your wishes are regarding that. Otherwise, the will really doesn't do anything until after you're deceased. But it does what people think it does. It directs who gets what as far as property that is actually controlled by the will at all. It also directs who's going to be in charge. That person's called the executor. And so the executor is the person who goes to the court after you pass away with the will, with some additional paperwork describing your assets, describing you, describing them. And the court reviews all of that and says, okay, this is appropriate. This is above board. I'm going to assign you as the executor. Now you're an officer of the court and you have obligations to report back to us, the court, what you gathered. You have to file an inventory. You have to publish notices in the newspaper. You've got to pay the final income taxes. There's this list of things you have to do. And the court's going to audit all of that and make sure you did it right. A will does not avoid probate. And that's often a misconception that people have. If you don't have a will, what happens is intestate succession applies. Again, another lawyer with poor naming skills. But basically, it's a will for people who don't have a will. And so in North Carolina, if you die, you don't have a will, we have a will for you that's built into our statutes that says what your spouse gets, what your kids get. And that's where a lot of people get in trouble when it comes to blended families. So successive spouses, children from a prior marriage. That is number one source of litigation in my office. It's absolutely insane. But the reason, and again, that reason is because of stuff like this. So in North Carolina, if you just own a piece of land by yourself and your spouse was never like part of that transaction, they were never added as a spouse onto your deed. Generally what happens with that, it depends on the number of kids you have. And so what you can end up having is you can end up having your surviving spouse owning a third of the property and have your kids from a prior marriage own the other 2/3. I mean, that could happen. And now you've got people that may have never met, might not even like each other, forced into a relationship where they've got sort of this constructive trust where they've got to make sure that they're not abusing the privileges of co-ownership of land to the detriment of each other. Now they all have to communicate and they have to agree on what to do. that's a difficult position to be in, no matter who you are. I mean, that's tough, especially if there's any sort of resentment about what else the spouse got instead. Often what you'll see in this arena is, you'll have successful spouses and you'll have children from prior marriages on both sides. And then pretty much without proper planning, what happens is one dies, the other one gets everything. If they maybe have this, they have like a sweetheart will, everything goes to the spouse and everything goes to the kids. Everything or a big chunk of stuff will go over to the spouse, and then the spouse will die sometime later and their kids will get everything, but the kids from the first marriage didn't. Or the kids from the first to die didn't actually get anything because they just happened to have the parent who died first. And so there's a lot of animosity, a lot of things that pop up during that process, a lot of anger, and a lot of mediation that has to happen. To the extent your will does control property, you do have the ability to create what's called a testamentary trust. And that's not an actual entity that exists now. It's a direction in your will to create an entity at your death, if it's needed, to manage property that's going to people that you don't want to directly get that property. It's usually in the case of minors, right? You don't want a child getting property too young. It could also be for an incapacitated or incompetent person, and that has a legally incompetent as a definition. It's a legal term. I know it's somewhat scandalous, inflammatory, but a person is legally incompetent when they're adjudicated so by a court. And so if you have someone who's legally incompetent under the law, you may not want them to get property directly. They might be on public assistance. They might, if you give them a bunch of money, they might lose those benefits until they spend it down. And some of these, so I've met people who have Medicaid and they get shots once a month that are $15,000 a month. There's a lot at stake for some people. Even if it's not a lot of money coming to them potentially. And so sometimes we'll create special trusts under a will to make sure they're not getting that money in a way that will cause them to lose their eligibility. But there are other circumstances, maybe you have an irresponsible adult that you need to, or a drug addict in your family or something like that, where you have substance abuse issues or mental health problems. A lot of times you're protecting people from themselves in creating these directions to create trusts under a will. And then guardianship. This is the one I get the most questions about, is how does it work when you die and you have young kids behind? Generally, there's a couple of different, the best way to describe it is there's different districts of court, different divisions of court, and each court, some things you can kind of cross over and you can do in either court or the other. Some things are exclusive to certain courts. So if you want to get divorced, you go to district court, right? If you want to sue somebody in another state for an amount exceeding $75,000, you have to go to federal court. There's just different rules that says where stuff goes. There's two different statutes that can be gone under. One is through district court, like a family law case, kind of, and DSS, social services, will be typically appointed as the guardian, and then your child will have an advocate, and there will be a process where there are orders entered regarding your child's care. We then monitor it, and then eventually the case ends and a guardianship is established with the person that you named, ideally. How it really works, though, is the court's interest. The court's not supposed to just give you what you want when it comes to this. They're supposed to rule in the best interest of the child, but they're also required to give great weight to your recommendation. So it's not really an appointment; it's more like a nomination. And so after you pass away, the court's going to want to see that. They're going to want to see your will. They're going to want to see who it is that you named, and they're going to want to probably specifically address that and make sure that we found, does anybody have any reason why these people are unsuitable? Because this is what the parents want, and that's usually the dominion in which the court wants to act if possible. Now, if you name a felon, heroin addict, the court may overrule you and may appoint someone else. That could happen. So that's why we usually say have a few backups too, if your first choice doesn't work out. And I will tell you, this is the part that husbands and wife, I don't get that many fights between spouses in my office, but when I do, it's usually about guardianship. Your sister's not raising my baby, that sort of thing. And so it really is about picking the least evil rather than the best option. And that's typically, that's how my conversation with my wife went. It's like, nobody's going to raise our babies like us, but who's going to do the next best job, right? Who's gonna damage our kids the least, right? That's the gist. So we have
Chris, going back to the testamentary trust real quick, is there a point at which, or is there a line in the sand where you decide, okay, I need a separate document for this.
Yeah, I'm glad you asked. Yeah. So there is this practice out there of having a will with a testamentary trust that basically at your death, you direct the creation of this trust for your kids, and then turning around after you're done having that will made and going to Edward Jones or Vanguard or these institutions and saying, hey, I have a trust now. I want to name that trust as the beneficiary of my retirement or my life insurance or my investment account. Okay. Now, that doesn't sound like a big deal, but in my lawyer brain, I've just got red alerts going off left and right because there's a very nebulous legal concept if you think about it, because it's not an actual entity yet. It's naming, like, it would be like naming a future company that your child creates that may or may not actually get created depending on what happens, as beneficiary of an asset. Like, it's a very nebulous or very difficult thing to sort of conceptualize. So my experience has been that if you do that, sometimes it works out fine. Sometimes the companies will let you do that. They'll say, okay, you can name the testamentary trust under your will as the beneficiary of this account. Some will just say, no, it's in our policy documents. You're not allowed to do that. Sorry. I've also seen middle ground where I've seen them say, okay, we'll do it, but then we're going to turn around and send you a letter saying we recommended that you not do it without telling you why. And so then I get these people who show up and go, hey, what does this letter mean? So I've seen that. That's the spectrum from of what I've seen in this field. So I have always referred to a will with a testamentary trust. Well, let me put it this way. There are some people where that works perfectly, but if you have like retirement, life insurance, things that traditionally would have designated beneficiaries, there may be creditor reasons or tax reasons why that really should be the case and not have your estate, your probate estate be the beneficiary of that. When that happens, it's sort of like a square peg in a round hole. That's sort of the analogy. I think it's like it could work fine, but then again, you might change companies and now you've got a different retirement plan sponsor, and now all of a sudden it doesn't work. I've definitely had people who got that done maybe elsewhere or here, and then they came back later and said, I got to get a living trust now. And the reason that you would consider the former first is because then if you've got a will with a testamentary trust, now you don't have a trust out there you have to maintain while you're living. You just go about your business as if there's no difference, which is convenient, right? It's more convenient to have a will with a testamentary trust. But then you have this nebulous issue about whether you can name it as beneficiary of property while you're still living on your accounts, and that's a difficult one to overcome. So the guardianship, let me run back to that. So that's the first mechanism is through district court with the court involvement and then the monitoring and then appointment of a guardian. There's also a separate process through the clerk of court. So the clerk of court, a lot of people don't know what that is. That's an elected position. It's basically the administrator of the county courthouse. That's what their job is, to make sure all the employees are getting hired and they're getting paid and the business of the court is happening as it should. That's one of their jobs. But in North Carolina, they're also judges of probate. So they deal with all the estate filings, foreclosure filings, incompetency proceedings, any sort of guardianship for minors in terms of managing money. And so there's a separate mechanism, separate from district court, that you can go through, and it's a little faster. It's maybe a 30-day or 60-day turnaround time, where you file with the clerk of court a petition for a guardian for a child. And as long as there's no living parent, you're allowed to go that route. And that is generally faster, and you're allowed to, but in that court in particular, you can get authority over the money that the child receives directly, and you can also get authority over his or her personal care. And then you can make those decisions. How one happens over the other is a little, it can be a little cloudy. I mean, there are I think it's very, very fact specific. If you have a situation where you pass away and things are just being smoothly handled, and there's really no disruption to the child's life, it's possible that the new guardians could just file a petition with the clerk. What happens more though is something suddenly happens to the parents, and now we've got police and EMTs, and then we got social workers going out to the house, trying to, making sure the kids are okay, making sure they have a safe placement. If that's the situation, you're very much looking at a district court situation where you're going to have that longer process, because social services has to go through that process. So it sort of depends on the circumstances of when you die as far as which process is more likely than the other. In either case, the judge is going to consider what you want greatly, and they're required by statute to. So I think we've talked a lot about trust, but there are some key indicators when someone's a real good candidate for a trust when you walk in my office. Someone who exhibits a desire for privacy more so than the typical person. Like I think I had mentioned earlier, the court system, a lot of what goes through the court system is public record. So I could go down to the courthouse, pull any estate file, see what's in it, see who's getting it, see who's getting what, see what fights there have been about it. There's none of those records are sealed. Even if they involve children, none of those records are sealed. So anybody can walk in there. Now, not during a pandemic maybe, because that's a little different, but during normal times, I mean, I walk in there routinely and pull files for various purposes without having to talk to anybody. So that's something anybody can do. There are people who are concerned with that, particularly, there are people who are more concerned with that, fit into I start hearing flags early on about that concern. So that's somebody who would probably benefit from a trust because it has a lot of privacy involved. And so some people from other states, from other countries come in, they have a very negative opinion from probate. They really don't care what I have to say about the differences here in North Carolina. They say, I want to avoid probate. That's my number one goal. That would be somebody who would benefit from a trust. The other one is the dead hand control usually over children, and making sure that the children don't get property directly, that it gets put into this entity. We put people in charge that we want. We have the amount of accountability that we want them to have, and not the amount of accountability that the court requires, which may be more or less than what you want. So it basically lets us create our own rules about how our kids' money is handled, and it's sort of the gold standard for that objective. I'll walk you through. So if you have all your property, regardless of whether you have all your property in a trust or whether you own all your property individually or whatever, or whether you're married or not, there may come a time where you need someone to step in and handle your financial life for you. And it may be incrementally, or it may be immediately. Maybe you suddenly get into a motorcycle accident and now you can't sign checks, and now you need someone else to do that for you. That is a function. That is something that if we did no planning, we might have to go to court, have you declared incompetent, appoint a guardian. That guardian would then account for your finances to the court and would have to get bonded and file filing fees, just like if we were dealing with a minor. And that's not something most people would prefer. So typically what we do is we do a power of attorney, and what that does is it makes a mirror copy of some of your rights. Now, it's a lot, when you think of your financial life, I would say that some of the things they can't do is get you married. They can't make a will, and they can't vote for you, but they can do a lot of stuff short of that. Okay. And so you don't want to just give that authority to somebody willy-nilly. I'd say the litigation that I've had over abuse of powers of attorney has primarily not been between family members. Well, sometimes it is, but often it's a power of attorney given to a caregiver, or a power of attorney given to a more like a family friend, or someone who's less trustworthy and doesn't have those bonds of family, overriding their sense of selfish, desire to receive money. I've seen millions of dollars of exploitation, sometimes all at once. And the common theme that I've seen is that when this gets exploited, it's because the people that were appointed were just not trustworthy on the front end, or their situation changed and they became untrustworthy. So I would say when you're doing this, you want to be very careful, because it is a lot of authority that you're giving to a person. You want to be very careful to name people you trust absolutely. And you know that they would adhere to their responsibility to look after your interest above their own in managing your assets. But it's a very convenient thing to have. So if I've used mine to deal with stuff when my wife doesn't feel like dealing with it. She's used it to deal with stuff. It's effective when we sign it. So when we sign it, I now have authority to handle stuff for my wife. So if she's on a business trip overseas and I need to sell my house, I can sell it. I can do what I need to do, and then as long as I'm not violating my duty to make sure her interest is looked after, it's perfectly acceptable to do. And then we have successor agents named, so that if something happens to my wife, suddenly we have backup options as to who takes over managing my assets. So it can be for convenience too, but it's primarily for one day, many years from now, you begin to suffer from some sort of decline, whether physically or cognitively. What I like about a power of attorney over a guardianship at that time, in addition to all the other stuff I just mentioned, is a guardianship requires you to get to a certain point before we go to court and say, now we're at that point, this person can't handle their own affairs, right? That doesn't happen on day one of a dementia diagnosis. That happens, maybe you've already done stuff against your own interest, and now we have the evidence we need. I don't particularly care for the idea of saying, okay, well, now we're leaving the door open at night and strange animals are coming in, and now you're eating rancid food that's been sitting out for 3 days, and now we have the evidence that we need. I would prefer that we plan on the front end so that before that's a problem, an agent under a power of attorney can incrementally step in, and maybe they help with one thing, maybe they help occasionally with another thing, and that can step up to being a full management of your assets at some point. But it doesn't have to happen all at once. And it doesn't have to embarrass the person. It can be a stepping stone for a lot of people, giving up control over their assets is something they've never even contemplated. So asking someone that's suffering from a cognitive impairment at that moment, who maybe does not have, and this is very common, maybe they don't have insight into the fact that they're suffering, right? I've certainly met people that have had like brain injuries and things where they can't remember, but they know they can't remember, and so they know not to trust things. That happens, but a lot of times with dementia, it's the opposite. It's I've got dementia, but there's nothing wrong with me. It's everybody else acting crazy, and so when you don't have that insight, that's a tough time to start planning. I would do it beforehand, because otherwise you're going to end up with maybe different results than you would have when you talk to a person and try to get their wishes out on the table. Because a lot of times what happens in these early and moderate stages of dementia, from my experience, is a lot of paranoia. And so in a lot of it is directed at the people who are in the best position to help. Maybe people who have helped for a long time, who are active in that person's life. Now they're the target of all the paranoia. Now they want to appoint different people. I'd say do it while you're healthy and young, if you're going to do it, right?
Those are all great points. And going back to something you said earlier, it effectively expires once the, I guess, grantor, if that's the right term, dies, correct?
Yeah, so it expires under whatever terms that you say it expires. So whenever you revoke it, or if you get divorced, you can specify the revocation conditions, but one which will always be applicable will be when you die. It's simply a document that has no bearing or no authority to continue to be used. It would be actually a crime to continue using it after the person has died. So usually what will happen practically on the back end is you'll have an agent under a power of attorney who serves until death. You'll have an executor or a trustee, or well, in this case, an executor who would take over once they get a death certificate and they can get into the courthouse and they can get appointed as executor. So you're going to have a few weeks of delay in between, potentially. I mean, it could be as few as 2, could be as much as a month or 3 months. But there'll be a delay in handling your affairs where nobody has actual authority during that interim. That's very normal and expected. Again, one of those things that trust planning often will mitigate, but that's a very normal thing to have that gap in authority. And sometimes agents under a power of attorney will misuse their power to like pay a funeral bill or to empty an account so they can do things. That has potential consequences. So you just have to be really careful with that part. So a lot of people ask me, well, can I make the document effective not when I sign it, but later when I'm actually incapacitated? That's called a springing power of attorney. That is one thing I think lawyers got right when they named it. It is, I think, almost universally among estate planning practitioners not preferred. It's not that it's a bad thing, right? But the idea is that we want it to be a smooth process. So the practical effect is I take this to some big no-name, big well-known bank, right? I'm trying to handle my mother's affairs, right? She's now, she got into an accident and now I've got to go handle her affairs. And I go to the bank with a power of attorney that's not effective until something happens to her. Now I've got a bank employee on the phone with someone with legal trying to figure out if the condition has been met, right? That's red tape. We want to avoid that, right? We don't want people in a bank trying to interpret whether a document is valid. We want it clear as day that it's valid. And so we often, usually pretty vehemently object to that if our clients ask for it. But ultimately it's their decision. So if that's something that they want built in, we do that. But more often what that means is we need to be having a conversation about the people you appoint. Because if you don't trust them now, while you have capacity and the ability to remedy mistrust, you're certainly not going to have that ability once you're incapacitated. And so if you feel like you can't trust them now, trusting them later is going to be a more difficult position to be in. And one thing I did want to mention about the will, one thing that someone did email me a question in anticipation of the seminar about spousal rights. And so I will go ahead and mention that. So with a will, you generally direct who gets what. But we also have rules in North Carolina that prevent you from disinheriting a spouse. And so there are a few different statutes that apply. Spouses get a range of different options they get to pick from. But generally speaking, if you've been married any length of time, there's going to be things a spouse has the right to, no matter what your will says. And the way to get around that on the front end is by planning around that. So if you're in a relationship where you both are bringing children into it, and you're in a blended family situation, you want to bring you want to bring that to the table while you want to make sure that each other's estates are being handled the correct way when you pass, because you might each in a successive marriage like that, a lot of times the couple don't intermingle their assets. They keep them separated. It's very, very common. And so the idea is that, look, the planning piece is usually those kids are going to get a bigger chunk, or ultimately we want to make sure they ultimately get whatever's left after the spouse is deceased. And so if we've got a will where we are providing for our own kids over our spouse, and it's not enough that our spouse is getting, or the spouse doesn't have enough rights to access that property, if we don't do it right, what happens is that spouse can come in and just chop a big old chunk of the estate right off the top. And if you do a prenup or a postnup or something where you waive those rights voluntarily on the front end, you can get around that. And so when I go and do a plan for somebody, maybe they're a divorcee, they've got a couple kids, and we're trying to do some planning for them. I'll always say, come back if you are planning to get married. If you find that bow, come back, because you will completely undermine everything I've done if you get married and you don't come and see somebody first. So that's a big flag. You want to make sure if you're in that situation like that, you plan ahead of time. And if you've already gotten married and you've got this situation, it's not too late. You can still do a postnup, or we can still waive that information or waive that right to make sure that your plans aren't being undermined. Because it does happen. I have a petition for an elective share pending right now where we have a spouse who didn't get enough under the law, and she's exercising her right to a different option. And spouses can claim the first, no matter what we do, unless there's a voluntary waiver, spouse gets the first $60,000 of personal property off the top before we even pay creditors. We have some laws basically going back to when men would die, their wives would be impoverished while the administration of the estate was taking place. And so they created this law that gave the spouse basically a year's allowance off the top, and to make sure that they weren't being impoverished while the estate was being administered. Well, over the years, that number has gone up as to what that year's allowance is, and now it's $60,000. It can be even higher under certain circumstances. So, for a lot of people, that we end up not even probating a will, because it's all going to the spouse, and the spouse can claim it all under their year's allowance, and then there's no need to proceed with an estate. It's a great tool, but it's also a tool that can undermine your actual estate planning objectives if you're in a certain situation. So just keep that in mind. The healthcare power of attorney. So this one's a little different than the durable general power of attorney. The durable general power of attorney was effective when you sign it. This document can go in and out of effectiveness. It's based upon your provider's determination about your ability to make and communicate medical decisions. So while you're living, you always make your own decisions. You can't really delegate that, right? But if you are incapacitated, then this document will kick in. And the doctor will go to the first person on the list. And if the first person on the list is either there or reasonably available, they will be the person who makes the decision. If they're not, then they'll go to the next person, and they'll go to the next person, and they'll go through your list until they have somebody who's reasonably available. And then they can have that person make decisions for you. This is also a really important one to get. I say that because there are some really weird rules about who does this, and it's not intuitive. For example, if I were to end up in an issue, if I were to be incapacitated and someone needed to make medical decisions for me and my wife was not available, the next in line would be the majority of my adult children and my parents. Basically, they would vote. And if you ever want to see an opportunity for conflict, take a young generation and then go up 2 generations and have those meet in a room and talk about medical care. That's absolutely the worst idea. So while it should always be a group decision, you really want someone that you can turn to who has the final say. And then the rest of the list is just as ludicrous. At one point, there's what I call the some guy statute, where it just says if somebody is with you and they claim to know about your affairs, then they can be your healthcare. They can be the person who makes your decision. So I could just walk into the hospital and be like, yeah, that's my cousin. I know all about her affairs. There's nobody else here, so I'll make decisions for her. Go ahead and pull the plug. That technically could happen. It's a weird statute. And eventually down the list, it's your doctor making that decision. And as much as I don't want to dog on other professions, just like lawyers get a bad rep because there's a few bad apples in the bunch, we're not all created equal when it comes to our willingness to put others' needs above our own. And so, it's a difficult job. If someone walks in and, I have a mortgage to pay and kids to feed, and I say to myself, this is a $600 job, not telling them it's a $5,000 job is not something. I mean, telling them it's a $5,000 job and they need the Maserati and not the Honda Civic. Me doing that is not something that has ever crossed my mind, right? Because my bar license is on the line if I do something like that, right? Like there's a fiduciary obligation that I put your interest above my own. The same applies to your doctor, right? But there are competing things, there are things that your doctor that weighs against whatever your best interest is that may serve their interest. And I don't want to put them in a position of having to be a decision maker and go, well, let's take a look at her insurance, and see if she's got good insurance or not. I'm not saying a doctor would ever do that, but it could happen. And so that person is ultimately on the list further down as somebody who ultimately can make the decision about whether to pull the plug, or whether you get therapy A or therapy B, or whether you get transferred to a different hospital. That's not something you want, probably. You probably want somebody that you trust, that you know currently, and not a future attending doctor that you may have never met. So the other thing that a healthcare power of attorney lets you do is a few post-mortem things. So unlike a financial power of attorney that ends at your death, a healthcare power of attorney goes after death just a little bit. And that's just to deal with the disposition of your remains. So the first thing that may happen is you may walk in, you may die, and we may not know why. And so the provider may, or the coroner may go and say, hey, we need to do an autopsy to determine cause of death. Can you sign here? That would be something that traditionally would be within the scope of authority of your healthcare agent, even though you're deceased. The other things are anatomical gifts. So if you want to donate organs, you don't want to donate organs, you want to donate there's all kinds of crazy controversial stuff you can do with your remains. You can body farms and art exhibits and all kinds of fun stuff. You can limit that authority if you want, but that's generally speaking what they would have the authority to do. And then as far as final disposition, whether you're cremated or buried, where you're interred, what song they play at your funeral, all of that stuff, if you haven't gone and made those arrangements yourself at a funeral home or with a cemetery, if you haven't gone and checked all the boxes and pre-registered, then the healthcare agent is the one who decides. That's the way the law reads. Basically, you decide if you've made those arrangements. If you haven't, then your healthcare agent decides. And so they're going to go to your healthcare agent and say, hey, what color box do you want, right? And when they do that, they're looking at the healthcare agent for that decision. And so if there's anything you don't want them doing, you probably want to specify that. So I'd say the most common has to do with either cremating or not cremating. Sometimes we have military members who want to be interred at a national cemetery or a particular one. Things like that are usually what we see. Of course, every once in a while we get a fun one in where there's all kinds of stuff about, cremating and spreading in certain places and, all that kind of stuff, being turned into a bullet and shot across a river, stuff. There's all kinds of fun stuff you can do with remains. Anyway, so that's the gist. That you can limit their authority. You can craft their authority around things you would or wouldn't want. I think probably the most interesting ones I get in this field are probably from Jehovah's Witnesses, because they have blood transfusion limitations and they have some very specific rules about what they can and can't get. And so a lot of times we'll have to build that in because a lot of times they'll name agents who aren't Jehovah's Witnesses and they simply won't know what the preference is otherwise. Or it's the reverse. Maybe someone wants to name a Jehovah's Witness and they don't want them exercising their authority in accordance with their faith. I mean, there's all kinds of stuff that comes up in that sector. But all that to say is you can craft that around your own belief system. And then that's the living will. Okay, so the way it works in North Carolina, all right, we're not like Oregon. We don't have an assisted suicide statute. We don't have anything that's going to allow you to take any sort of affirmative act in someone's life. That's not in existence. It was on the table a few years ago. I think our legislature has bigger fish to fry right now. So what happens is you basically have to be on the cusp of death anyway from something that's incurable or irreversible, or you have to be unconscious and the doctor says you're not going to wake up to a high degree of or to a high degree of medical certainty, or you're in the last stage of some substantial cognitive problem like late stage dementia where your quality of life is extremely poor and there's nothing we can do to sustain your current cognitive health. We're not able to reverse it. We're not able to help you wake up. We're not able to help you cure or reverse the course of the illness that you have that's going to cause your death in a short period of time. So we're talking like days. I mean, when we're at that moment, right, that's we know it's inevitable, right? You've had your 5-year battle with cancer. You're at the last leg of it. We're basically, part of us is kind of waiting for the relief of suffering that we're witnessing. You know, there's a lot of conflicting feelings. Like that's where we are. We're in that last hour. And when we're there, you know, we want clear instructions because, you know, we do not want family with different perspectives about this. I'll tell you, I get a 20-something in my office, you know, they want to get their will done. You know, I ask them these questions and they say something like, oh my God, no, I would never want life prolonging measures withheld. Now, why do they say that? Well, their perspective is formed by their observations, and all they've observed are the headlines with a kid who wakes up after a year after being declared brain dead, right? Like they're forming their position. They think it's very normal for someone to wake up from a coma, even though all the doctors said you're not. That's not really that normal. So when I get a medical provider or someone over 50 in my office, almost uniformly, they say the opposite. They say, oh my God, yes, please pull the plug. I would never want my family to go through that, or them to even have a say in that. So, you know, we get different perspectives. And so what we don't want is people fighting about it, right? We want the appearance of a group decision. We want everybody to feel heard, but we don't want to hold things up that don't necessarily need to be held up if we know what your wishes are. So traditionally, how I like to do this is I like to craft it one of two ways. Either you basically say something like, I don't necessarily want my life prolonged by artificial measures if the benefits don't outweigh the risk or whatever. And we have some very, you know, colorful language that makes it pretty clear. Like you need to consider my beliefs. You need to consider the expected outcomes. You need to consider all the detriments. You need to really look at this picture. But ultimately, I'm going to have the same person that made my medical decisions for me about therapy A and therapy B and private room or double room and all those other decisions. I'm going to also have them be my boots on the ground and be the final decision makers about whether to pull the plug or what measures to withdraw or withhold. You can leave that up to someone else. And I see that a lot, but I also see a concern about naming adult children that, you know, maybe they're younger adult children. I also see concerns about just naming certain people in general and having to leave that burden on them. So there's a lot of different ways to approach this problem. But the second way I like to draft it is I draft it as an instruction. So it basically says, I understand I have this other person making medical decisions, but when it comes to this issue, this is too important. I'm going to say that they don't have authority over this issue, and I'm going to make it an instruction. Now, in reality, there's so much wiggle room in the statute. It's insane how much wiggle room there is. I mean, the hospital can object, the doctor can object. If people start raising issues about the legitimacy of the document, they can just say, well, we're just not going to follow it. I mean, there's definitely a lot of like provider stuff in there that gives them a lot of wiggle room. So the reality is, if you've got a healthcare agent or another family member who's jumping up and down screaming, don't you dare kill my daddy or whatever, you know, you're not going to have that happen. They're not going to say, sorry, you're not part of this decision. I'm going to go ahead and do it. Right? The liability isn't with you, who you know, they might have to eat an ICU bill. The liability is with the person jumping up and down saying that document's not valid. Right? So the reality is that it may not work out the way that I write it, but I want it to be clear with everyone that reads it that this is what you want. So we can apply non-legal leverage to a family member. We can say, look, he paid a lawyer. He put it in bold. It says it doesn't matter what you say. Are you really going to be a jerk and not honor your dad's last wishes regarding this? You know, there's going to be a lot of leverage that folks can use to help facilitate the discussion and hopefully ultimately do what it is you want.
Chris, do you understanding every situation is different? Do you have a general recommendation as far as whether someone chooses a family member or someone who is less attached to the family?
I think across the board, people name family when it comes to the medical stuff. I think it's almost the exception that they would appoint a third party to make those decisions. A lot of times people default to who has the most medical training, which isn't, that seems like a pretty logical way to think about it. You know, who's going to be best suited to make medical decisions for me? Well, my cousin's a nurse, and you know, my sister's a doctor, whatever, right? Like that makes perfect sense. I would say the better characteristic to have would be a mediator's mentality, right? The ability to listen to all the opposing viewpoints, make everyone feel heard, take everything into account, and the ability to facilitate. I mean, ultimately, maybe you have that authority to do it without all of that, but the ability to sort of finesse the family dynamic and make sure that everybody's satisfied with the outcome, and you're not going to spend the rest of your life defending your decision. Yeah. Let's see. So that's all I had. So let me turn it over. I don't think there's a chat function in this. I'm fairly new to this platform. I don't see any questions.
I really appreciate your last comments, because I don't know that I've heard someone give direction like that as far as the characteristic of naming someone. So I appreciate that.
Oh yeah, I would say in general, family, close friends are the folks that most people go to for any sort of fiduciary role: trustee, executor, power of attorney. That's usually who folks go with. This is actually a common problem that comes up. We have this sort of phenomenon right now. I mean, we've got 70 million baby boomers in retirement and nursing home age, and a lot of them don't have anyone that can serve in those roles. And so what we're finding is when you run out of people, you have to resort to professional options many times. And so you may end up going with like corporate solutions like big banks or small banks to be service trustee or executor. Sometimes lawyers and CPAs and some advisors, will serve as fiduciaries in these other roles because the person just simply doesn't have anyone. One of the underserved areas we've seen is in the role of like power of attorney. There really hasn't been until recently any mechanism, any professional associations that provide that service where they act as an agent under a power of attorney for people. It's just not something that's that common. And so now that there's more of a demand for it, you're seeing more, the industry is developing around the need. So there are organizations now, I know of at least one that comes to mind, is very popular, called the Corporation of Guardianship, that they help with things like special needs trust. They can be the trustee, they can be an agent under a power of attorney for an elderly person who doesn't have anyone. There are professional solutions that come up if you really don't have anybody, but usually we're looking at that as a last resort for most people. Professional options, I mean. For some people, they want to immediately go to a professional option, not necessarily for things like healthcare or things like that, but for finances and being a trustee and things like that. Sometimes you want someone outside the family who can say no. So like, for example, if you have, like, I've seen this situation happen many times, right? You have two kids, right? You got one who's got the good sense and one who's addicted to substances, right? And you have to protect number two. Well, you basically say, well, I want number one to get his or hers outright. I don't want hers to be managed in trust, but I want the other ones to be managed in trust. Right now, you've already got some animosity between the two kids, right? Well, how come mom said that my share has to be managed, right? Now the issue that we have is sometimes what they do is they name child number one to manage child number two share. Now you got one child that's sort of subservient, right? They got to come, they got to ask, say, can I have some money to pay my rent? And then, and child number one would have to say yes or no to that. That's a difficult position to put child number one in best of circumstances. So sometimes people will jump immediately either to more distant family or to friends or to third-party professionals that they've had dealings with. I don't often recommend myself because that seems, first of all, it comes across extremely self-serving in the first 15 minutes of a conversation. The second thing is you haven't known me very long, right? At this point in the conversation, you wouldn't have known me. So I would. Some people want to, and that's fine if they do, but I usually put it in writing, like, hey, look, you can appoint whoever in the world you want to be the executor or trustee or whatever role it is. And you really should just look at a professional under certain circumstances, or if you've run out of other options.
Great.
Yeah. So I guess this has been a real pleasure, Andy.
Yeah, thanks for teaming up on this, Chris. And I don't know if you're able to see any questions or anything coming across.
No, there haven't been any questions. Thankfully, I think we did a really good job of explaining things. I'll pat myself on the back for that one.
I will make that assumption.
All right.
So really appreciate everybody participating. I think you've heard from the way Chris spoke. His approach is again, not to generate billable hours, but really to understand what you are trying to accomplish, and then putting the mechanisms in place so that your wishes are granted. You know, we run our practice the same way here. It's just trying to do whatever is in your best interest, and we've got established processes to create a strategy that works best for you. So thank you for taking time out of your day to talk about this stuff. Most people aren't willing to do that. So I am humbled by your participation.
All right. Well, if there's no further business, we will adjourn. And if you guys have any questions about anything at all, you want to follow up privately, you've got our information here on the screen. Don't hesitate to reach out. Please, I think I can speak for Andy when I say we really want to be a resource for you. And if you have questions about this sort of stuff, because I will tell you, I make the majority of my money on the back end from the people who don't plan, trying to clean up the mess afterwards. I would far rather make a little money on the front end, helping you avoid that mess for your family. So don't hesitate at all to reach out if you want to if you'd like to use this as a resource.
Well said. Well said.
All right. Okay, guys. Well, take care.
Yeah, make it a good one.
Bye.